So I'm being told the live stream is now on and we are now in session. Thank you very much, everybody. And for this final, which is being streamed live on YouTube, I'm very happy to welcome the teams from MIS and from Singapore Management, who have throughout the competition, like all the other teams, shown exceptional knowledge, exceptional hardworking advocacy, and exceptional collegiality towards the other teams. So I have the great honor now for this final usually the occasion of the final of the Moot is a happy occasion, but we are living in very different and difficult times. So a final in a competition dedicated to the peaceful resolution of international dispute is almost an act of defiance against what is going on in this world. And for that, I introduce Funke Adekoya as presiding arbitrator of this tribunal. She is I would say, preeminent Nigerian lawyer, ICSID annulment committee member, and also a very lovely person, as are they all. Then for the claimants appointed arbitrator, I welcome Lucy Reed, professor of law, president of SIAC, and the presiding arbitrator of the very first tribunal that I appeared before 19 years ago. So, which I think was your first one as presiding arbitrator, may have been, perhaps. So we all go back a long time. And respondent appointed arbitrator Claudia Anaka of Decade. And we also crossed swords in the past on a case which I think is still live, which is kind of scary and contrary to, dispute should be resolved speedily, etc. Anyway, for today's final, none of the three ladies will be themselves, even though you should address them by their own names, not by the names in the case study. They will ask questions which are not in any way indicative of their personal opinions, positions, etc. So any challenge to them on the basis of a moot final is by definition doomed to fail. They also have explicit instructions from me to be mean and brutal and cruel to the teams in asking you questions. That is not or is not their nature. It's in fact against their nature. They're all extremely nice and measured arbitrators in real life. So with that kind of list of warnings and other things, I have the great pleasure to hand over to Funke for the final. Oh, sorry. No, actually, I'm the tribunal secretary, and I nearly forgot to ask the administrative preliminary matters. So claimant and respondent, have the teams agreed on the order of issues, other than that we do the challenge first, and the allocation of time? Claimant, please.
Hello, everyone. It is an honor to be here today. Well, I will first go with an introduction of my team, if that's okay, and then talk about the allocations. My name is Mahtab Javadi, and I will be addressing issue number 2 on behalf of the claimant today, along with my co-counsels, Mr. Amir Mahdi Dehqan and Ms. Mehnoush Jambakhsh. And we will be assisted by Ms. Zahra Khati. We have discussed with the respected respondent in this regard, and we did not reach an agreement over 2 issues. It is respondent's request that they go first on all 4 issues. However, we would like to go first on issue number 1 and issue number 3. Therefore, we left it for the respectful tribunal to decide. And lastly, about time allocations, for us, we shall reserve 9 minutes on issue number 1. 1 minute for rebuttal, 11 minutes for issue number 2, 1 minute for rebuttal, 10 minutes on issue number 3 and 1 minute for rebuttal, and then again 11 minutes for issue number 8 and 1 minute for rebuttal. I suppose the respectful respondent has a different time allocation from now on, I ask them to represent their time allocation to the respectful tribunal. Thank you.
Greetings to everyone and members of the tribunal. My name is Justin Lai, and together with my co-counsel, Mr. Keith To, we appear on behalf of the respondent. And we would propose that the respondent goes first for all issues, given that we are challenging jurisdiction. As for time allocation, I'll be taking 11 minutes for issue 1, and 1 out of those 11 minutes will be reserved for rebuttal. And for every other issue, we will take 10 minutes and have 1 out of those 10 minutes reserved for rebuttal.
Madam President, as to the order of appearance, would you like to make a decision or leave that to the Secretariat?
I think that in real life, the arbitral panel would actually have a discussion on it, but in these circumstances, I would leave it to the Secretariat.
So by the power illegally delegated to me by the President of the Tribunal, I decide that claimant should go first on C1 and on 1 and 3, and respondent should go first on all the other issues. And I will also be the timekeeper, assisted by Catalina Bisek, who has acquitted herself very well throughout this week, as everybody knows. Madam President, with that, I hand back to you.
Thank you very much, Secretariat. Can I now ask the parties to start with addressing the tribunal on the challenge to the arbitrator? We have read the challenge and we have read the response to the challenge, and we'd like to hear short oral argument in support of the challenge and opposing the challenge.
Madam President, apologies. May I clarify that you want to hear the entirety of the arguments relating to the challenge to Mr. Kujas right now?
Yes, we would.
Okay, much obliged.
And I should clarify that as that arbitrator, I will listen, but of course I will not interject.
If I may begin.
Please do, we're waiting for you.
My apologies, Madam President. Wasn't the issue stated by Madam Secretariat that the claimants go first on issue number 1 and 3, and for the respectful respondent to go first on the rest, or
Yes,
is it your decision to go otherwise?
Now we start with 8, and you did not request to go first on 8. We start with a challenge.
Okay, my apologies, please.
Madam President, members of this tribunal, good day to you all. As introduced, my name is Keith To, and I appear on behalf of the respondent. I will now address you on the issue concerning the challenge to Mr. Kujas as arbitrator before the present proceedings. Now, Article 15.1, read with Article 8 of the ICSID Additional Facility Rules, allows for a party to call for the disqualification of an arbitrator for, inter alia, a manifest lack of ability to exercise independent judgment. And this has been accepted to include both a duty of independence and a duty of impartiality. Now, our position is that Mr. Kujas ought to be disqualified as arbitrator from the present proceedings because the current facts raises justifiable doubts with regard to his impartiality. Now, at the outset, we want to point out that Mr. Kujas has a duty to disclose his participation in both the present proceedings as well as the Welser proceedings. However, he has failed to do so, and in fact, he continues to fail to do so for reasons known only to him. Now, while we are not saying that this ought to be determinative, we are saying that this should be a relevant consideration taken into account by this tribunal as a factor weighing in favor of finding that he at least shows an appearance of impartiality.
Counsel, could you please explain to the tribunal why you feel that the opposing side's suggestion that the documents in the other proceedings should be disclosed to you would not solve the issues of some sort of imbalance in terms of the knowledge available to the rest of the panel?
Madam President, respectfully, we would say that firstly, there is no legal basis for the claimants to seek record disclosure from both proceedings and have the records of both proceedings shared to all or both tribunals. And the only way that this sharing of record would be possible is if they obtain the consent of all the parties here. Now, not only does Spain not agree to the sharing of the records in the present proceedings, we note that the claimants have failed to even get the consent of the Welsers family too. So we first say that this option should be dismissed on this grounds. But furthermore, Madam Arbitrator,
is the lack of consent of the Welser family on the record?
No, Madam President, but at the same time, the claimants have failed to establish that the Welser consent is indeed present on the record. And in any event, Madam President, we would say that this option is still unsatisfactory. Now, insofar as it may go to cure any information asymmetry, it does not address the real issue here, which is that there is a manifest risk of prejudgment on the part of Mr. Kugis. And I'll go on to address why there is a manifest risk of prejudgment later. But first, let me tell you why. Another reason why the sharing of the record would be an unsatisfactory option to us, the respondent. And this is because of a very simple reason. The evidence that they seek from the Welser proceedings should be protected by banking confidentiality. And this is something that the respondents take very seriously because it draws, or rather it raises issues of national security. Now, on this basis alone, we say that the Welser record cannot be shared to the present tribunal and to the Fugger family. Furthermore, as I mentioned earlier, Madam President, there is a strong, or rather a very serious issue here of a manifest risk of prejudgment on the part of Mr. Kugis. Now, such a manifest risk of prejudgment arises where there is a significant factual and legal overlap between the two proceedings. And if this overlap gives rise to an appearance of lack of impartiality, we say that a manifest risk of prejudgment can be found, and accordingly, Mr. Kugis should be dismissed from the present proceedings. Now, first, it is our position that there is significant factual overlap between the two proceedings, and that such facts are relevant to the determination of the legal issues in both proceedings. Now,
for the benefit of the tribunal, could you just highlight one area of overlap?
Certainly, Madam President. Now, the similarity in facts can be seen from how both disputes concern a common party, being the respondent Spain, and both claimants in the present proceedings also are in the same industry, being that of loans, or rather banking lenders who loan to the respondent Spain. Furthermore, both parties in these proceedings are complaining of the same events. If I may refer this tribunal to page 3 of the case study.
We've seen that we are at page 3.
This tribunal will see that the Welser family was also affected by the same 1557 default as well as the 1560 settlement, which gives rise to the present claims brought by the Fugger family. Thus, we say that the complaints and the the facts in both proceedings are exactly the same. Now, the similarity does not stop there. This is because the Fugger family have brought their claims, or rather they are complaining of breaches of the CCC. Now, the Welser family are also relying on this exact same bilateral investment treaty in order to found their claims. Thus, on this basis, members of the tribunal, we would say that there is a sufficient and significant overlap in both the facts and legal issues in both proceedings. Now, second, it is our position that such an overlap in the facts and the law give rise to an obvious lack of impartiality on the part of Mr. Kyrgios. Now, in the ICSID case of Karatube and Kazakhstan, the tribunal held that an arbitrator cannot reasonably be asked to maintain a Chinese wall in his own mind, as his understanding of the situation in one proceedings may very well be affected by his knowledge derived from the arbitration proceedings separate to the present proceedings. Now, given the significant overlap between the facts and law in the Welser claims and the Fugger claims, we say that despite his best efforts, Mr. Kyrgios may unwittingly make a determination in favor of one party as a result of being privy to external information not in the record of the present arbitration. Now, for example, he will be hearing the arguments from both sides, and essentially he will be hearing 4 sets of arguments, 2 claimants and 2 respondents. Now, insofar as it comes to a position of law, say whether or not the Salini test applies, he will have whatever he decides in one proceeding will definitely affect his decision in the other. Now, in this way, his judgment cannot be said to be completely independent or impartial, as it will naturally be colored by what happens in the parallel proceedings. On this basis, Madam President and members of the tribunal, we say that there is a manifest risk of prejudgment on the part of Mr. Kyrgios, and accordingly, we kindly ask this tribunal to dismiss him from the present proceedings. Now, Madam President had earlier queried about the possibility of the sharing of the record, and I had already addressed this tribunal as to why such a possibility is simply an unsatisfactory option for the respondent here. And I also note that the claimant have proposed another possibility, which they say would cure any risk of impartiality. And we say, and this suggestion put forth by the claimants is that of appointing the same arbitrators in both proceedings. Again, our position is that such an option is simply unsatisfactory. First, it is a fundamental principle of arbitration that parties should be allowed to appoint whoever they so please as their own arbitrator. Now, insofar as the claimants want to appoint the same arbitrators in both proceedings, this would deny the respondent of such an option, and we say that this breaches the principle of equality of arms. Second, the Welser Tribunal has already been appointed. Now, insofar as they have already been appointed, what the claimants is essentially asking is for the entirety of the rest of this tribunal to be dismissed so that Mr. Kyrgios can remain on this tribunal, and that we should appoint the same arbitrators in the Welser proceedings to the present proceedings. We say that this is simply an unreasonable request because it is so inefficient. Instead, the simpler position would be simply to ask the claimants to dismiss Mr. Kyrgios before the present proceedings, and accordingly, we say that the challenge should be upheld. Now, members of the tribunal, I note my time, unless I may address any other concerns this tribunal may have.
Now, Mr. To, could you briefly address the timing of this challenge? You are aware under Article 8 of the additional facility rules, any challenge needs to be made promptly. Could you very briefly address that requirement and how it is fulfilled in our case?
Certainly, Madam Annika. Now, we do note that Article 34 of the ICSID Additional Facility Rules requires parties to bring any challenges promptly. However, we say that there is no express specification as to the number of days within which proposals for disqualification must be brought, and instead the promptness inquiry must be assessed or ascertained on a case-by-case basis. And this was held in the 2007 ICSID case of Suez and Argentina. Now here, we say that the challenge is brought promptly. Now, insofar as the first letter sent by King Philip is concerned, we note that the respondent has a plausible justification for why it was delayed, and that is simply that the letter was lost at sea. Now, the tribunal may then query as to why this first letter does not contain any challenges to Mr. Kyrgios' arbitrator. Now, we say this is simply because King Philip was not yet advised as to his legal position in this regard. Now, in fact, it is stated at page 14 of the case study there that the moment King Philip duly retained counsel, he sent a follow-up memorial containing more detailed arguments. And in this follow-up memorial, he does set out the challenge to Mr. Kyrgios. And in any case, we do not know when this second letter was sent, but we do know that it was received very quickly after 15 August 1564. And we say on this basis, this tribunal should find that the promptness requirement has been satisfied.
Thank you.
This is my submissions on issue 8.
Thank you very much. In the absence of any other questions, I would then ask for the response from Claimant's Counsel.
Thank you, Madam President. Members of the tribunal, esteemed colleagues, good day. As mentioned before, my name is Mehrush Jean-March, and along with my co-counsels, we represent the claimants in today's proceedings. In the next 11 minutes, I will be discussing issue 8 on part of the claimant, and I reserve 1 minute for rebuttal. Members of the tribunal, I will be mirroring the arguments raised by the respectful counsel for the respondent, and in this regard, I will be discussing 3 major points and 3 major issues. The respondent puts forth first that there has been, and there is, in fact, an overlap of the facts of the case, and 2, the overlap of the facts and laws of the case could result in a lack of impartiality. And lastly, they address the claimant's suggestion for a de facto consolidation in case of existing issues. Members of the tribunal, Madam Arbitrator brought up the matter of timing, and in that regard, we will push aside this matter first, as it has to do with the format, just to ensure that we can have a relevantly smooth pleading. Members of the tribunal, we do not disagree that the respondent has in fact put forth its challenge to the arbitrator in time. It is in fact mentioned within the exit rules and the exit drafting history that there isn't a specific time in which a party would have to absolutely put forth a challenge. And this is fluid and has to do with the timing in which a party becomes aware of the potential for the challenging of an arbitrator. And thus, we're not in disagreement at all with the respondent regarding this specific point. Moving on to the rest of the issues, the
Counsel,
yes.
do I take that to mean that you have no complaints as to the timing of the jurisdictional challenge?
Not at all, Madam President.
Thank you.
Thank you. With regards to the first point brought up by the counsel for the respondent, the counsel for the claimant has to ask, what standard is the respondent putting himself in way of? Within the exit convention and within the IBA additional facility, within the exit additional facility rules, there are 2 general sets of standards that have been subject to scrutiny through the years since 1966, a higher standard and a lower standard. The respectful respondent first argued, and I quote, "The challenged arbitrator must at least show an appearance of impartiality." But then it moved on to argue that there is a manifest risk of prejudgment and a significant overlap of the facts of the case. Now, this wording and the wording that the respondent used is specifically of importance because we must clarify under which standard are we taking into account these facts of the case? Is it the reasonable third party's point of view, or is it the manifest lack of the qualities that we're observing? these standards, as mentioned before, have gone up and down again throughout the years and have not stayed the same. They've gone through a roller coaster of situations, first starting with the Amico Asia case, in which the standard was quite high. And then right after the Amico Asia case, the standard of reasonable third person's point of view became into question. Now, the standard has never been the same throughout the years. And the arbitrators have argued for either side on multiple levels and in multiple situations. We argue that under the high standard and under the low standard both, Mr. Kujas does not show that they have, in fact, shown impartiality that would push the tribunal to set them to the side. Members of the tribunal. If we do look into the arguments made by the respectful counsel for the respondent, we can see that they argue that the evidence within the case is one that is similar to the Welsers case. They argued first that they are both, the disputes both discuss the same respondent. Second, that they are within the same industry. And third, that they are and the matters of the case are the same. And we do not argue that the subject matter of this dispute could potentially look similar, but there's a difference between the subject matter of a case and facts and legal issues of a case. In the Iran Claims Tribunal, this matter was discussed and brought into attention. There's a difference between subject matters being the same and facts and laws being the same. Yes, the subject matter is the same. The Welsers have engaged in activities similar to the Fuggers. They have given loans to the emperor, and they have been shorthanded and had been subject to heavy debts. That is a true fact. But at this stage of the proceeding, we cannot possibly know that these facts would overlap in any shape or form, as we do not know what the Welser claim actually entails. We do know that the Welsers were subject to the 1566 state of the empire. We do know that they settled or presumably settled with the empire, but we do not know what their claims is and what they are actually bringing before the tribunal. And this was a fact that was mentioned by Madam President. What are the similarities of facts and law that overlap so greatly that has pushed the respondent to argue that the cases are factually and legally the same? And how has the respondent decided at this stage of the proceeding that the facts overlap? This was a matter that was discussed widely in the PIP case. In that case, Professor Fadallah was subject to the challenge made against him at a very early stage in the proceeding, in which the facts of the case were not discussed yet. The Welser case has not begun yet, and the Fuggers case has just started. And thus, we cannot know for certainty whether or not the facts overlap. Moving on to the second point raised by the respectful counsel for the respondent, such an overlap, and they argue, shows an obvious lack of impartiality. Again, if the respondent is arguing that there's an obvious lack of impartiality, they're favoring themselves toward the least, the lower standard under which an arbitrator should be subject to a challenge. These standards are of a third party's point of view and reasonableness and an appearance of bias. So, as Professor Dale has discussed, there are three generations and three ways in which we can look into the term manifest. It appears that the respectful respondent argues that what must be manifest within a case is the facts. And for the facts to be manifest is enough for an arbitrator to be challenged. The facts of this case are not manifest. If we put before a reasonable third party of the sorts, the fact that the Wassers and the Fugers are two banking families within the same country. They have been in communications and in business dealings with the same respondent, but we are unsure as to what exactly they're bringing before the tribunal, and we are unsure as to what exactly it is that will be discussed in the proceedings, and we're unsure as to what legal matters are going to be discussed and what factual matters will be brought up. This does not hold up to the scrutiny of the high manifest lack test or the lower test that the respondent appears to be leaning towards. In this regard, we have to put a link between our argument for the standards and the look we have had to the facts of the case specifically. Under the high standards, there has to be proof that there will be, in fact, a high potential for the arbitrator's state of mind, which is, I must add, within itself a concept that is yet to be grasped by humanity. What is the arbitrator's state of mind? How should we know that an arbitrator feels impartial or feels biased within its state of mind? The facts must be manifest. They must be 100% or at least close to it, and they must directly point to an arbitrator's impartiality. The counsel for the respondents brings up a test which we assume is the test under which the Karatuk versus Kazakhstan case was decided, because the respondent said that there's significant overlap of the facts, and second, that the relevance of this overlap is obvious to the eye and visible to a third party without any other information. This specific case, the Karatuk versus Kazakhstan case, and the standards set by this specific case, which has been one that has been used in other tribunals, such as the Blue Bank case or the recent Antalya versus Georgia case, was a case in which the disputes had progressed. And thus, all in all, we must argue that Mr. Kujaz is in fact not impartial. In fact, man must not be subject to the scrutiny. And lastly, a de facto consolidation is the way. Consent is a matter to be discussed within international arbitration. And all in all, this arbitrator must not be set to decide. If I am of any further assistance to this respectful tribunal,
I don't know whether my co-arbitrator has any questions.
I have no questions at this point.
Thank you very much. Then we'll go on.
I am so sorry. It appears that I had a slight delay in my pleadings. If I am of any further assistance, or if there's need for me to repeat my last bit of arguments, I am available to the tribunal. I do apologize for the technical difficulties.
Thank you very much, counsel. I think we actually did catch the last bit up to the point of if there's anything that you could be of assistance. So we believe that we got your arguments. Since my co-arbitrator has no questions at this point, we'll then go on to rebuttals.
Thank you so much. I do apologize again.
Members of the tribunal, just one point in rebuttal. Now, the claimant had earlier tried to say that there was no overlap between the present proceedings and the Welser proceedings because we simply cannot know what the legal issues in the two claims entail. However, we say that this is a disingenuous and untenable position for the claimants to take because they clearly don't believe in it. Now, at page 17 of the case study, in the claimants' memorial themselves, they state, and I quote, "This will in particular help the claimants show that discrimination they have suffered in addition to all other breaches that all claimants in the separate proceedings have suffered." We say that this clearly betrays their true assessment of the situation. unless this tribunal has any more concerns. This concludes our case on the issue of the challenge to Mr. Kyrgios.
Thank you very much, Respondents' Counsel. Claimants?
Thank you, Madam President. Members of the tribunal, in line with our efforts to be not a disingenuous party, as the counsel for the respondent argues, we say that yes, this statement could be read as to the claimant's information, as what we discussed, but the claimant has argued and feels as if it has been discriminated against compared to all parties that the respondent has had dealings with, not just the Welsers. And this is a claim that the claimant feels as if it could have potentially some merit if the Welser and the Fugger case are in fact consolidated in a de facto consolidation. If that is all, and if there are no questions, and if I am of no further assistance to this tribunal, I rest my case. Thank you so much.
Thank you to counsel on both sides. I would just ask my co-arbitrator, Ms. Haneke, have you heard anything that would change our discussions based on the written submissions prior to this oral hearing?
No, I haven't.
Thank you very much. In that case, the tribunal, having reviewed the written submissions on the challenge prior to this hearing, and having listened to the parties on both sides, have not changed the position initially, which we had initially made, which is that the challenge to the arbitrator is unmeritorious, and we dismiss that challenge, and we'll now proceed with the full hearing. So with that, I welcome my co-arbitrator, the third member of the panel, back onto the panel, and she will now be able to fully participate in the proceedings with us.
I'm very relieved and happy to reiterate my impartiality and independence with the qualification that in real life, the decision probably would have gone the other way.
Thank you very much. So can we now proceed in line with the guides that the Secretariat had put? I believe that the claimants are taking issue 1. Yes. I'm sorry, you can't hear me.
No, we can't hear the claimant.
Counsel.
My apologies,
The claimant
Madam
is
President.
muted. Okay.
Thank you. Madam President, honorable members of the tribunal, good day. It is my honor and privilege to be here today before this respectful tribunal. My name is Amir Mahdi Dehkhan, as it was mentioned. Along with my co-counsels, we will be representing the claimants on this session of the tribunal. And in the next 9 minutes, I'll be covering issue 1 on behalf of the Fuggers, George, Raymond, and Christopher, the claimants. Members of the tribunal, issue 1 is concerning whether the Fugger loans could be protected under the CCC and exit additional facility rules as protected investments. With regard to this question, I will make a twofold submission. Firstly, the granted loans fall within the definition of investments under the Constitutio Commercialis Carolina, CCC Article 1.6. And secondly, there has been investments within the meaning of exit additional facility rules, and also the Fugger loans can fulfill the requirements of Salini criteria, even the tribunal wish to apply these tests. To proceed on my first submission, I must mention this reality that the investments of capital takes a multitude of forms, and definition of investments in treaties tend to be broad and open-ended. The purpose of ratifying the CCC in 1530 was to provide maximum protection for investors and to liberalize the investment and trade. mentioned on the preamble of the CCC, and that was the reason why the figures was one of the strong supporters of the CCC in time of its ratification, mentioned on page 4 of the case at hand. Members of the tribunal, with regard to Article 1.6 of the CCC, there has been various grounds which implies the loans as protected investments. Firstly, the definition of investment in this article is open, general, and not restricted, as it is stated in the case of RREEF versus Spain, which was held under the Energy Charter Treaty, a modern version of the CCC with exact wording of the Article 1.6, in which the tribunal held that the definition of investment in this article is open, general, and not restricted. Also, in the case of UCAS versus Russia, the tribunal held that the definition of investment in this article, which was the Article Energy Charter Treaty, which for the purposes of page 1 was the modern version of the CCC, the tribunal in this case indeed also held that the lists of the investments in these Article 1.6 is not exhaustive. Secondly,
So, Council, before you keep going on Article 1.6, you made a reference to the preamble, which says that the whole purpose of the CCC is to catalyze economic growth by means of measures to liberalize investment and trade. At a big picture level, what does that have to do with your clients making loans to royalty who are waging war with disastrous economic and trade consequences?
Madam Arbitrator, would you please clarify your question?
How can, if we look at the preamble, which says that the whole point of this investment treaty, like all investment treaties, is to promote investment and trade between states, investors and states, how can a loan to an royalty who needs the money to wage war, which always damages economies, fit as a general matter under the umbrella of this treaty?
Madam Arbitrator, actually the loans, however, not all of them were paid for the war purposes. For instance, in the page 10 of the case at hand, apologies, the page 7 of the case at hand, when Spain was in financial difficulties and he couldn't able to pay its debts, actually he tried to require more loans from the FUGER. Therefore, all loans were not for war purposes. Even the loans for war purposes, as we know, this security is a basic level for the economic growth. If there is war or chaos in the society, therefore there would be no basis for economic prosperity.
Thank you, Council.
Moreover,
before you go on, may I ask something? You were discussing Article 1.6 before, and I understand you emphasized the non-exhaustive nature of that definition, the breadth of the definition. Is it your position that the investments at issue in our case don't fall within any of the categories listed in Article 1.6?
Thank you for your question, Madam Arbitrator. Indeed, it was my first ground, a general one, but secondly, I was about to mention that on the paragraph C, it states that claims to money and claims to performance pursuant to contract having an economic value and associated with an investment is regarded as actually protected investments. In the case of TEDx versus Venezuela, the tribunal held that every kind of asset, including claims to money and loans for the purposes of this article, are protected investments, which has got a similar wording like the paragraph C of Article 1.6. Moreover, on the last paragraph, it is stated that in the a change in form in which the assets are investments does not affect the character as investments. That's why we firstly argue that the definition is broad and open and not restricted, And on the second place, for the purposes of paragraph C, the fugger loans should be regarded as protected investments.
Thank you. Could you elaborate a little bit on the express requirement associated with an investment in literacy? You explain its claims to money or claims to performance. How are the claims at issue here associated with an investment?
Madam Arbitrator, actually, from the Maximilian Charles V time to this Penn default in 1557, there has been a chain of loans, a chain of lease of revenues, which are connected together. In each chaos, in each war, in each financial difficulties, the Spain or the Holy Roman Empire required more money, and the fugger obliged. They was due to each other, and they were as a chain of loans. That's what we propose.
Counsel, I can understand the chain of money, and I can understand the loans consolidated. What I would like, and I believe that's what my co-arbitrator wants clarification about, is I would like the linkage between the loans and the investment. What is the investment?
Madam President, for the purposes of the definition of investment in these regards, it is our understanding that each of loans are regarded as investments per se, and because there has been a chain of loans, they are together with each other. But there has been another ground for being associated, if that's when the fuggers paid loan to the emperor or to the Spain, but they could not able to pay these loans back. And for the purposes of these disability, they are required more loans to pay the previous loans. That's why we argue that this is resembles the situation as a chain of loans, which are connected together. Madam President, as I see I'm running out of time, with your permission, if it is possible, I require 1 minute to conclude my second submission and a brief conclusion of my whole submissions, if it is possible.
Please proceed. We did interrupt you.
Thank you. To proceed on my second submission, firstly, for the purposes of Article 3 of Additional Facility Rules, the provisions of the exit convention are not applied. Therefore, which is the claimant's submission that the Salini test should not be applicable for the purposes of dispute, even if the tribunal want to adopt these tests. Therefore, all requirements are fulfilled, including contribution to money, duration, investment risk, and contribution to economic development of the whole states. All in all, members of the tribunal, it is the claimant's submission that for the purposes of the loans, fugger loans being regarded as the protected investments under the CCC and Salini criteria, even if it is applicable, this tribunal has jurisdiction ratio in materia with regard to these loans. Unless I may be of a further assistance to the tribunal, that concludes my submissions.
Thank you very much. I don't know if any of my co-arbitrators have any other questions.
No, thank you.
In which case, thank you. In which case, I would ask counsel for the respondents to proceed.
Good day, Madam President and members of the tribunal. As earlier introduced, my name is Justin Lai, and I act as counsel for the respondent. I'll be now taking 10 minutes to go through issue 1 regarding the jurisdiction, rationale, and materia of this tribunal. It is our position that this tribunal does not have jurisdiction, rationale, and materia, and we have 2 submissions to make in this regard. My first submission is that the loans do not fulfill the definition of an investment within the relevant investment treaty, the CCC. My second submission is that the loans also do not fulfill the objective criteria embodied within the Salini test. Turning now to my first submission, we submit that the loans to the emperor do not satisfy the definition of an investment within the CCC And I kindly request this tribunal to turn to Article 1.6, which defines the term investment. Article 1.6 defines an investment as, I quote, every kind of asset owned or controlled by an investor, followed by a list of examples from A to F. Given the existence of the list of examples, parties must have intended to limit the scope of investment to some extent. And the list of examples here is in pari materia to the list of examples in the Energy Charter Treaty, hereinafter ECT. In the ECT, this list of examples was subject to extensive renegotiations and kept changing throughout the entirety of the 100 drafts of the ECT. Now, if these examples were merely illustrative, there would have been no point for parties to engage in such extensive negotiations. The relevant example here is Article 1.6c, which requires that claims to money be associated with an investment. And as Madam Annika earlier queried counsel for the claimant, this requirement of being associated with an investment, and it is our position that it has not been met in the present case. As stated in the PCA case of Yukos Capital in Russia that interpreted this same provision in the ECT, it is not a case that a loan considered in isolation is ipso facto an investment. And as Madam President earlier queried the counsel for the claimant on whether the link between the loans could qualify as being this separate investment, we say that such an interpretation is clearly untenable and flies in the face of the plain and ordinary meaning of the clause.
Counsel, if these loans, extensive loans necessary to keep your government and your king afloat are not investments for purposes of the treaty, what exactly were they?
Madam Reid, we would respectfully disagree with the characterization that these loans were necessary to keep our government afloat. There were many other creditors, such as the Genoese and the Welser, who also extended such loans to us, and we would characterize such loans as a simple one-off commercial transaction. And this is because the loans were given in order for the emperor to pay his debt or to use it however he saw fit, and there is no investment risk associated with them, which is also a point that I will touch on later. And furthermore, members of the tribunal, counsel for the claimant has neglected to mention a further requirement in Article 1.6 of the CCC. If you could turn to the very last line under Article 1.6, it states, I quote, investment refers to any investment associated with an economic activity. Now here, there is clearly no economic activity, as this was a simple loan to the emperor to pay off his debt. And thus this additional requirement in Article 1.6 is also not satisfied. And therefore, on this basis, we would argue that these loans do not constitute investments within Article 1.6 of the CCC. I now move on to my second submission, which is that the word investment in the ICSID additional facility rules has an inherent meaning, and criteria such as the Salini test must be satisfied. Now, the present proceedings are brought under Article 2 of the additional facility rules, and Article 2 has two alternative routes. First, Article 2A requires the dispute to arise directly out of an investment, and Article 2B, read together with Article 4.3, provides that even if the dispute does not arise directly out of an investment, the underlying transaction still must have features that distinguish it from an ordinary commercial transaction. Now, this clearly suggests that the term investment has some objective meaning and is to be distinguished from simple one-off transactions. Such a distinction makes sense because states could not have intended to promise investment protection for ordinary commercial transactions, and this was noted in the 2011 ad hoc arbitration case of Alps Finance and Trade AG and Slovak Republic. Now, accordingly, in the tribunal case of Salini and Morocco, the ICSID tribunal came up with 4 objective criteria to identify an investment: a contribution, a certain duration, a risk, and a contribution to the development of the host state's economy. Now, this approach has been adopted in many subsequent cases, such as Joy Mining in Egypt and MHS and Malaysia. Thus, the word investment in Article 2 of the Additional Facility Rules must have the same meaning as the term investment in Article 25 of the ICSID Convention, since ICSID could not have intended for the two different standards to apply to the same word. Now here, we argue that the criteria of investment risk has not been satisfied. Investment risk centers around the idea that profits are not ascertained as a fixed amount, but depend on the success of the underlying economic venture concerned. The key reason why investment risk was introduced is to distinguish investments from ordinary commercial transactions, in which commercial risk, such as the risk of default, is present in all such transactions. Thus, in the 2015 ICSID case of Postova Bank and Greece, it was held that Greek sovereign bonds were not investments because these did not have any underlying investment risk, and the worst that the claimant or the investors in that case could have suffered was the risk of default. Now, investment risk will therefore, Madam Annika, I know the concern.
Thank you. Just a quick question on your position that there is mere commercial risk. Isn't it the case that here there was an enactment of degrees, so there were sovereign acts that interfered with the repayment of the loan and ultimately led to even a default on the loan and back that default?
Yes, Madam Annika, we would agree that there were sovereign acts in this case. However, as explained in Postova Bank, sovereign interference constitutes a risk considered as sovereign risk. And this is also distinguished from investment risk, since sovereign risk equally applies to all transactions that could have happened during that period of time. And therefore, we would still contend that investment risk has not been satisfied.
If I look at Article 1(6)(b), bonds and other debt of a company, what would be your position on corporate bonds and corporate debt? Wouldn't that be the same with respect to sovereign debts, with respect to the risk aspect?
Madam Annika, we would respectfully disagree. While we know that Article 1(6)(b) does contemplate loans to a company, this is to be distinguished from loans to countries and sovereign bonds. Now, there is a significant difference between debt of a company and sovereign bonds, because sovereign debt can be used for many things other than to support investments. And therefore, this was recognized by the ICSID Tribunal in Postova Bank and Greece, that because sovereign bonds could be used for a wide variety of purposes that could not be investments, it was not the case that sovereign bonds would be investments. And furthermore, Article 1(6)(b) contemplates loans to a company, and oftentimes these companies are involved in underlying economic ventures. And this is just simply not the case in the present scenario. Members of the tribunal, I note that my time is running out. To simply summarize my case, this tribunal has no jurisdiction rationale materiae, as the definition of investment under the CCC and the definition of investment in the additional facility rules are both not met. Now, this actually brings me to the end of my submissions, but I'll be happy to take any concerns this tribunal may have.
Thank you very much. I do have one question, and that is, where do you place the leases on the Maestragos that the claimants were forced to take over as part of the Zuga settlement? Would that not constitute an investment?
Madam President, certainly it could constitute an investment under Article 1(6)(a) of the CCC, which includes rights such as leases, and we are not contesting that in our present case.
So you would take a view that some part of the claim is validly before the tribunal, but not all of it?
Certainly, Madam President.
Thank you. I don't know if any of my co-arbitrators have any other questions.
Not before rebuttal.
Thank you very much. In which case, can we move on to rebuttals?
Yes, Madam President. The counsel for the respondent truly mentioned that the investment should be associated with an economic activity, but we have to take it into account that it should be just associated with economic activity. It shouldn't be per se an economic activity. For the purposes of page 7, when the Spanish business was unsettled, it required more loans, and also these loans were associated with the Fugger banking business, which entails an economic activity, but it is associated, and however, it is not per se an economic activity. Moreover, regarding the commercial transaction, which the counsel for respondent mentioned, the war purposes and chaos, it's not per se an investment risk. It's not per se a commercial risk. It is more than that. It is an investment risk, which this is what we propose actually. Thank you.
Thank you very much. Rebuttal?
Members of the tribunal, just one point in Sir rebuttal. Counsel for the claimant has brought up the fact that the Fugger lending business qualifies as an economic activity. However, this is an incorrect way of interpreting the requirement. As the case of Yugos Capital and Russia has held, this economic activity is distinct from the act of making the investment. And therefore, the fact that the Fuggers are in the banking business cannot be used to qualify as an economic activity. Otherwise, every single loan or transaction that the Fugger business makes will automatically be considered an investment. And this is an untenable interpretation. This concludes my Sir rebuttal.
Again, Counselor, I have a high-level question. Do you deny that your country benefited from the loans that were made by the Fugger? Economically benefited?
No, Madam Reid, we do not object to the fact that our country did benefit from such loans, but it still does not mean that they qualify as investment.
Do you deny that there was risk involved in the Fugger making those loans?
No, Madam Reid, we do not deny that there were risks, but we say that these risks are separate and distinct from investment risks, which are clearly required to distinguish an investment from an ordinary commercial transaction.
Thank you.
Thank you very much. I believe the next issue is issue 3. I think the claimants had agreed they would go first on that.
Madam President, have we addressed issue 2? I mean, okay, yes, issue 3 in the order of our proceedings, but the next issue is issue 2 for the case study. Sorry for clarifying.
I apologize. Yes, issue 2. So respondents, issue 2.
Members of the tribunal, I'll be continuing the case for the respondent and now address you on issue 2, which concerns the bribery of the Fugger. We say that such bribery should lead to a dismissal of the present claims, and we say this for 2 reasons. Firstly, the Fugger did commit the act of bribery by giving gifts to Iraso, who was the secretary for Emperor Charles and King Philip. My second submission will be that such bribery should render the present claims inadmissible. Turning to my first submission, the Fugger resorted to bribery by giving gifts to Iraso with the intention of getting repaid ahead of other creditors. While the legal test for bribery differs from state to state, the UN Convention Against Corruption, hereinafter UNCAC, obliges contracting parties to impose a minimum legal standard. Now, to comply with their treaty obligations, states would have implemented legislations that at least mirror the UNCAC. Now, the definition of bribery in Article 16.1 of the UNCAC has 2 elements. First, a person offers an undue advantage to a public official. And second, he did so with the intention of obtaining an undue advantage in return. Here, it is our position that both elements are satisfied. Turning to the first element of giving an undue advantage, this element is satisfied as the fuger offered gifts to Eraso. If the tribunal can turn with me to page 7 of the case study. In the last paragraph, specifically the first line, there it is stated that, I quote, the fuger tried to win Eraso's support with small gifts, and this was after a letter was sent to him saying that he was being held in disfavor because he had not been giving gifts. And this letter was sent in 1557. Now, the second element of receiving an undue advantage is also satisfied.
Counsel, I'm very impatient in general with these bribery arguments in these types of cases. It takes two to tango or to dance, and here an agent of your government solicited quote unquote small gifts. Does not that affect your argument here?
Madam Reed, we would respectfully disagree with such a characterization. It is not stated anywhere in the case study that Eraso solicited such loans. In fact, the claimant decided to attempt such bribery on their own volition after coming to the conclusion that they were being held in disfavor. And in any event, we would say that even though, and we are contesting this, that if there was bribery engaged on both sides, then this would not aid the claimant either, as bribery would render such claims inadmissible no matter the party to the bribery.
But you just referenced the letter in the record that referring to the fact that Mr. Eraso was unhappy that he had not been given gifts and the like. I would call that a solicitation, wouldn't you?
Madam Reed, we would again respectfully disagree. Although our agent may have expressed such unhappy feelings about not being offered gifts, this amounted in no way to any compulsion for the fuger to offer such gifts in the end. And now, moving on to the second element of receiving an undue advantage, we would say that such an intention is also satisfied because the fuger offered such gifts with the intention of jumping ahead of other creditors during a state of insolvency. Members of the tribunal, it must be borne in mind that in 1556 and 1557, Spain had encountered severe financial difficulties and was undergoing a state of insolvency. And if members of the tribunal can turn with me to page 9 of the case study. The second paragraph specifically, the first sentence, it reads, and I quote, already in 1556, Philip had his agents initiate negotiations with his creditors to obtain, if possible, their voluntary acceptance to a composition of debt. Now, as one of Spain's biggest and most major creditors, the fuger certainly would have known about this. And if the tribunal can turn with me to the next page, page 8, there it is stated that in 1557, King Philip ordered a deferral and subsequently a halt on all payments to the creditors. And it was in this context that the fuger realized that he may not get his investment back and therefore turned to bribery in order to obtain what was already deemed to be his. And therefore, we would say that Article 16.1 of the UNCAC is satisfied and there is bribery on the facts. I now move to my second submission, which is that such bribery should render the present claims inadmissible. And we say this for two reasons. Firstly, the obligation to combat and prevent bribery is part of customary international law. And second, the fugers do not come to this tribunal with clean hands. I shall first address my point on customary international law. While we recognize that the CCC does not contain an express legality clause, international custom is a source of international law pursuant to Article 38(1)(b) of the ICJ statute, which this tribunal can apply and take into consideration. Now, custom is formed when there is first widespread and consistent state practice, And second, such practice carried out in the belief that the practice is required by law, also known as opinio juris. Now, in this case, the custom to combat and prevent bribery can be derived from the fact that 185 states signed the UNCAC and undertook the obligation to combat bribery and, in accordance with Article 5, implement legislation against bribery in their countries. Now, the fact that the UNCAC reflects the position that customary international law is recognized by the ICSID Tribunal in the 2019 case of Lao Holdings and Laos. In line with this widespread international consensus to combat bribery, we argue that this tribunal should find the present claims inadmissible, as this approach could effectively curb bribery and deter future investors from engaging in such misconduct. And now,
Council, one question. I understand your position is we do have jurisdiction, regardless of whether there is bribery, right? But
yes,
we should declare inadmissible. Now, even assuming that there is a customary international law rule or a general principle of law that you have referred to, how do we get to the result that we should not exercise the jurisdiction that the CCC confers on us? Is your position that whenever there is bribery, either during the procurement or the performance of investment, we should just dismiss the case as inadmissible?
Madam Annika, certainly we note that there is a distinction between what I shall call pre-investment bribery and post-investment bribery in international law. However, we are arguing that since no case has had to deal with a fact of post-investment bribery, as in this case, dealing with the admissibility of the claim, we nevertheless submit that this tribunal can find this claim inadmissible for a very strong reason that it is in line with international practice and CIL in order to combat and deter bribery. So going back to your first point, Madam Annika, I do acknowledge that this tribunal does have the jurisdiction to hear the claims, but we are arguing that you should not exercise this discretion. Move on to the second reason for inadmissibility, which is the clean hands doctrine. Now, this doctrine is a general principle of international law and operates on the basis that legal remedies should not be available to an investor whose illegal conduct relates to his claims. And this doctrine has been applied in the 2016 ICSID case of Churchill Mining and Indonesia and the 2014 PCA case of Al Warab and Indonesia. Here, the figure did not come to this tribunal with clean hands. Now, if they felt aggrieved by the fact that they were not getting back what was owed to them under a contract, they could have simply sued in the national courts of Spain or take other legal remedies to settle this problem. Instead, the first thing they decided to do was to resort to bribery. And thus we say that since they do not come with clean hands, this is another compelling reason for this tribunal to find the claims inadmissible. In conclusion on this issue, we would reiterate our submissions that first, the figure clearly and factually bribed Eraso in an attempt to jump ahead of other creditors, and second, that such bribery should render the present claims inadmissible. Unless I may be of further assistance to this tribunal, this concludes my main submissions for this issue.
Counsel, are you seriously contending that an option for the Fugger was to sue the Spanish government in the Spanish courts?
Yes, Madam Reed, we would say that that would be the logical first choice of action, first course of action, apologies.
Thank you.
Unless my co-arbitrator has many questions, I do not have any. Madam Annika?
I have no further questions now.
Nor me, thank you.
Thank you very much. So could we then go to the claimants on issue 2?
Thank you, Madam President. With regards to the submissions of the respectful counsel for the respondents, we would have to make a couple of points. First of all, we do not disagree that in case of occurrence of bribery, an investment would obviously be affected. However, we disagree with the fact that the definition of the bribery is applicable in the current scenario due to the foregoing reasons that I'm about to mention. Emphasizing on the fact that due to the definition brought up in this tribunal, the respectful counsel for the respondent states that a business partner, first of all, offers, and second of all, undue advantage. Here, we are going to distinct from this opinion. I will be making a twofold submission. Firstly, it will be argued that Fuggers were the victims of extortion rather than committers of bribery. And secondly, and alternatively, regardless of the nature of the corrupted act, there is no link between the conducted measure and Fuggers' investment whatsoever. Moving on to the first argument, stating that Fuggers have been extorted by Mr. Arasso and are in fact victims of the extortion. To support this argument, I will be demonstrating the difference between bribery and extortion and precise application of extortion in the scenario. Bribery is defined as a corrupt benefit given or received to influence official action so as to afford the giver better than fair treatment. Both the person giving the bribe and the recipient, of course, is guilty of bribery. However, as I stated, we do accept the definition stated by the counsel for the respondent as well. On the other hand, coercive extortion by a public official is the seeking or receiving of a corrupt benefit paid under an implicit or explicit threat to give the payer worse than fair treatment or to make the payer worse off. The payee is guilty of extortion, the payer is victim of extortion. The line between bribery and extortion, members of the tribunal, is rather blurred when a public official expects bribe are these two acts. Surveys in different countries have found that businesses and citizens often have little choice but to pay what is asked for. Consequently, if a business owner is left with no choice other than paying a government official for an action they are paid to carry out in the first place, then we could conclude that the business or person is literally extorted in this scenario. My apologies. Now, if the tribunal is with me, I would like to address you to page 7, paragraph 4 of the case at hand, in which it has been mentioned, and I quote, that Arasso was openly hostile to the Fugger, which shows that he already was not treating the Fugger in a fair way. This fact is in contradiction with what the respectful opposing counsel brought up. He stated that we were asking for undue advantage, while that was not the scenario. There was no undue advantage. And alternatively, I would have to, again, cite the respectful tribunal to the case at hand, page 7, paragraph 6, again. It is the letter sent to Anton Fugger by Ortel in April 1557, in which it is stated that Arasso and his man kept on telling everyone that, I quote, "From no one do we have so much trouble and so little profit as from us," meaning the Fugger. Madam President, members of the tribunal, this shows the explicit expectation of financial benefits by Arasso for carrying out what he was supposed to carry out in the first place. Now, I would have to move to our second submission under first argument, which is quantity examination. Extortion is distinguishable from bribery by quantity examination. There exists another method for distinguishing extortion from bribery, which is investigating the amount of financial benefits received by a public official. For instance, according to a survey done by UNODC in Western Balkan, roughly 1 in 10 businesses that have had interaction with public officials in 12 months prior to the survey paid bribe to a public official. However, in Nigeria, for instance, most bribes are solicited by public officials in return for a service that is their duty to deliver. This suggests that in such cases, bribery is not simply seen as a kind of administrative lubricant to smoothen the bureaucratic process, but rather as a scheme to extort money or other types of bribe from people. Now, again, if the tribunal is kind enough to bear with me, I would like to address you to the last paragraph of page 7, which was again invoked by the opposing counsel. He pointed out the first line. I would like to address you to the rest of the paragraph, which states Eraso had extricated gifts from all major banks, lending to the emperor and the king over the course of 14 years. He had become rich man, mostly by accepting gifts. This suggests that extortion was Eraso's normal way of dealing with people. He would do it literally with anyone. Now, if the Fuggers were the only ones who gave him small gifts and provided him with some type of financial benefits, then we could consider the possibility of commission of bribery. But since this was Eraso's normal way of dealing with everyone, it can be understood that not all of these business partners could be corrupted, but the corrupted person here is Eraso, who committed extortion on a large scale. Also, the state of Spain, according to the footnote of page 12 of the case study, states that Mr. Eraso's criminal responsibility is being exhausted internally as well. So they accepted that he was corrupted. Moving on to our second argument, Madam President, members of the tribunal, in this regard, we state that there is no link between the corrupted act and Fugger's investment whatsoever. Apologies. To elaborate on this claim, we submit that regardless of the fact that whether the act committed was bribery or extortions, Fugger's investment are in no way constituted through this act, so that we could actually consider the respondent's second arguments with regards to admissibility of the claims. Considering the intentions in this regard, Fuggers were acting in Eraso's favor in order to be able to get their own money back, not to invest new amounts of money. Therefore, there is no link between the Fuggers investment and the acts committed, regardless of the nature of the fact. I would love to refer you to the investments made by the Fugger. Now, I am about to cite the dates, Madam President, members of the tribunal. First one is May Strasgos, which is started in 1524. Second, we have loans to the emperor. First one is consolidated loan, which is related to year 1552. Then we have Village loan, again 1552. And lastly, we have loan to Philip, which is for 1557. And on the other hand, the only date related to the bribery, supposed alleged bribery, is 1557, which is the letter which has been sent to Anton Fugger. Therefore, it is our submission that there is not a single fact indicating the relation, time-wise, the relation between the corrupted act and Fugger's investment. Therefore, it would not in no way affect their investment and would in no way affect the admissibility of this respectful tribunal. To conclude, Madam President, members of the tribunal, we state that bribery has not been committed by the Fugger due to the definitions brought from bribery and extortion, and Fuggers were rather extorted. And even if the respectful tribunal decides that the act was bribery, which was not, there is no link between this corrupted act and their investments. If I'm of no further assistance to this respectful tribunal, and in case of question.
Counsel, what about a response to the respondent's position that the Fugger acceded to extortion, to use your term, instead of protecting themselves? In other words, did not they become complicit and therefore convert extortion to bribery?
Madam Arbitrator, we do have a text and we do have a context, we need to interpret the Investors Act within the context. We should look through the committed act and see the situation Fuggers were in. Again, if the Fuggers were the only one who did this, then we could state that there is a possibility, and it would be actually considerable to call this bribery. But then we see that all major banks were being extorted by Mr. Arasso. And on the other hand, due to paragraph 8 of page 10, we see that Fuggers were actually at the boundary of bankruptcy. I am mindful of my mind, but I would like to complete my answer to a question, if that's possible. And then, as I was stating, Madam Arbitrator, we were facing somewhat of a bankruptcy. And in case we wanted to bring it up to Spain's authority, which is highly unlikely that they were actually not informed of this act, and it seems that they were not that much thoughtful to care for this matter. And again, if we wanted to take this matter to the tribunal or even exhaust it internally, we would face the crisis of bankruptcy. Therefore, it is our submission that Fuggers were forced to pay those allegedly small gifts. And if they did not at that time, and if they refused to do so, they would have been bankrupted at that time, Madam Arbitrator. Thank you for your question. In case of other questions, I'd be more than glad to assist the tribunal. If not, I rest my case.
I have another question, counsel. Is it your argument that because the claimants were operating in an environment where everybody had to give a bribe to get business done, which is what you say is extortion, therefore they are not complicit, nobody's at fault, and therefore this tribunal should exercise its jurisdiction and settle this dispute in spite of the evidence provided as well by the claimants that they did give bribes. They were small gifts, but small is relative.
Madam President, with regards to your question, firstly, I'm going to answer it in 2 points. Firstly, I believe that the respectful counsel for the respondent did not bring up the matter of jurisdiction. Therefore, if I'm not mistaken, we are discussing admissibility over here. And with regards to admissibility, Madam President, it is our submission that we have to draw a line between bribery and extortion. And in case this respectful tribunal finds that the committed act falls within the scope of extortion, then we could conclude that Fuggers were victims, and so as all other major banks who had to pay Mr. Arasso for carrying out what he was supposed to carry out in the first place. If that answers your question, Madam President.
Thank you. We'll move on.
Thank you, Madam President.
Can we then go to rejoinders?
Members of the tribunal, 1 point in rebuttal. As Madam President earlier queried counsel for the claimant on whether it matters that the claimant was complicit in the bribery, or even if the industry was rife with corruption, we say that this simply does not aid the claimant, as already recognized in the case of World Duty Free in Kenya at paragraph 181. It does not matter which party is corrupt. Any party who brings such a claim will not be able to rely on investment protection. And this concludes my rebuttal.
Thank you very much. Sorry, rebuttal.
Madam President, with regards to the point brought up by the opposing counsel, even if the tribunal decides to follow the precedents in the Kenya case and decides to declare that the action was bribery rather than extortion, it is our second submission an alternative argument that the investments was in no way constituted through this act due to the dates that I stated in my proceedings. Therefore, the tribunal has every right to go through the details, and the claims are admissible before this tribunal. Thank you for your time and indulgence.
Thank you very much. I don't know if any of my co-arbitrators have any questions on this point. Otherwise, we shall move to issue 3.
I have a quick question. It's primarily for the respondent. If I understood you correctly in your case in chief, and perhaps I didn't, I thought you referred to the needs of Spain in order to avoid bankruptcy, to renegotiate and or annul the loan repayments. If that is indeed what you said, doesn't that prove that the loans were investments in Spain?
Apologies, Madam Reid. Sorry, could I get you to repeat your question? I had some audio technical difficulty during the first half.
Sure. If I understood you correctly in your case in chief presentation, and perhaps I didn't, I thought you made reference to the fact, or said that the needs of Spain to avoid bankruptcy led to and justified the renegotiation or annulment of the loan repayments. If that's your case, doesn't that in a sense prove that the loans were investments in the first place? Investments in Spain in the first place?
Madam Reid, that would certainly be a valid concern if in this case there was an investment within either the meaning of the CCC or the Salini criteria. However, in any event, we would say that just because a creditor makes a loan to, say, a company or a state, that does not automatically make it an investment, even if it does help contribute to, let's say, the state of insolvency, perhaps.
Thank you.
One quick question, if I may. Question for the claimants. Did I understand your position correctly that if we were to find bribery here, for the sake of the argument of researching the question, this tribunal should just turn a blind eye and should assume jurisdiction, should declare the claims admissible, and then just go on with the merits and damages award?
Madam Arbitrator, in fact, if this respectful tribunal finds that the action was bribery rather than extortion, then it is our submission that the loans have not been constituted through this. Therefore, yes, it is our submission that the claims before this tribunal are admissible and the tribunal should go through the merits of the case. However, to complete my point, Madam Arbitrator, however, we do accept the fact that a bribery would violate international public policy and is in larger scale an awful conduct to be carried out. But then again, it wouldn't actually be in connection with the investments of the Fugger. I suppose we are going through investment in this tribunal.
Arbitrator Annika, are you satisfied with that response?
Thank you. No more question.
Okay, thank you very much. We would then go to issue 3. I believe the claimants are leading on that.
Madam President, honorable members of the tribunal, good day. It is my honor and privilege to be here today before this session of the tribunal. As it was mentioned before, my name is Amir Mahdi Dehqan, and I will be representing the claimants on this session. And in the next 10 minutes, I'll be covering issue 3 of the case at hand. Members of the tribunal, issue 3 is concerning whether the Fuggers could be considered as foreign investors with respect to imperial claims, and whether the claims against the emperor could be brought before this tribunal. I will make a twofold submission for the purposes of this issue. Firstly, the Fuggers are foreign investors with regard to the Holy Roman Empire. And secondly, the claims against the emperor are capable of being invoked before this tribunal rather than the Ali Council as the Supreme Court of the Holy Roman Empire. To proceed on my first submission, I may call the attention of the tribunal to the name of contracting parties of the CCC, which is stipulated on the case at hand, page 4, paragraph 3. The tribunal is with me. It is in the actually stated that the treaty, the CCC, was finally ratified as a mixed agreement by the Holy Roman Empire and its territories, as well as Charles V on behalf of his territories outside the empire. It is their claimant submission that the "and" as a conjunction between the Holy Roman Empire and its territories implies that the territories of the Holy Roman Empire ratified and entered into force CCC as a distinct contracting party, which is exactly in line with the clarification records of the case, paragraph 10, which mentioned that all empire members ratified the CCC. As we know, the Augsburg is an empire member, which ratified the CCC in line with the paragraph 10 of the clarification records of the case at hand. Moreover, there are other grounds at the case which shows that the Augsburg is an independent contracting party to the CCC on page 1, if the tribunal is with me. As its names imply, it is a free city which was not under the authority any prince, neither secular nor clerical. Moreover, this city was not subject to imperial taxes, and this city actually controlled its own trade. Moreover, with regard to page 18 of the case at hand, it is mentioned that the Holy Roman Empire should be regarded as the contemporary European Union. As we know, the European Union is consisted of multitude of territories which enjoys independence and autonomy. It is just like the territories of the Holy Roman Empire. However, there are member states of the empire, but they enjoy autonomy and independence and could indeed be a contracting party of the CCC. That's why the claimant argues that the Augsburg is indeed a contracting party to the CCC and is not a part. Actually, it's not not independent part of the Holy Roman Empire or Spain. That's why we wonder why the council, the respectful counsel for the respondents, mentioned in their skeleton that the Augsburg and Spain are both parts of the Holy Roman Empire, which is in flagrant contradiction with the fact sheet on page 4, paragraph 2. If the tribunal is with me, it is mentioned in the first sentence. Charles V was king of Spain and Portugal, as well as the emperor of the Holy Roman Empire, but neither the Spain nor Portugal was part of the empire. Moreover, to proceed on my second submission, I must mention that the claims against the emperor falls into the jurisdiction of this tribunal because it should be regarded as a different contracting party, as an investment of different contracting party. Actually, the claims against the emperor, if they want to be brought before the Ali Council, as we know, the Ali Council as the Supreme Court is under the control of the emperor. If the claims against the emperor are brought before the Supreme Court, it would be a conflict of interest. That's why we argue that they falls within the jurisdiction of international arbitration tribunals, as they are two distinct contracting parties of the CCC. Moreover, it is our submission that the loans granted to the emperor are attributed to Spain. There are two grounds for that. Firstly, for the purposes of Article 4 of the ILS draft articles on state responsibility for internationally wrongful acts. This article mentioned that the conduct of an organ is attributed to the government and to that state. And for the purposes of estoppel principles, which is an international principle, it is mentioned that the alleged state would be precluded from asserting something contrary to what is implied by the previous pertinent judicial determination. If the tribunal is with me, on page 11 of the case at hand, please. The paragraph before the paragraph before the title Haynes Jacobs last service, last sentence, it is stated that in the settlement, the Spanish court recognized the village loan, although it had been granted to the emperor. The village loan was granted to the emperor, but the Spanish court recognized it and adopted it. Therefore, Philip II was responsible for the due payments of the village loan. However, it was granted apparently by the emperor. Moreover, in the settlement, the first paragraph, the maestrazgos as well were recognized. Therefore, it is the claimant's submission that these loans, maestrazgos and village loan, all are adopted or are recognized by the Philip II and Spanish courts. Therefore, they are indeed attributed, and Philip II is responsible for the due payments. Another ground is that the substantive features of these loans. What was the maestrazgos for the purposes of page 4, last paragraph? The maestrazgos was revenues of Spanish crown. However, it was apparently granted by the emperor, but at that time, the emperor was both the emperor of the Holy Roman Empire and king of Spain. The maestrazgos is a list of a Spanish crown, which we should be taking it into account that it was the king of Spain. However, it was the Charles V on that time who grants these loans. Moreover, what was the village loan also were secured in Spain. The village loan was secured in Spain and mortgaged up to 1557, which shows that these are all attributed to Spain. All in all, it is the claimant's submission, members of the tribunal, that for the purposes of the figures being regarded as foreign investment with regard to the Holy Roman Empire and Augsburg as an independent contracting party, therefore the tribunal has jurisdiction ratione personae with regard to the figure, and the claims against the emperor could be brought before this tribunal because they are indeed attributed to Philip II, king of the Kingdom of Spain. Unless I may be of further assistance to the tribunal.
I have a question, counsel. Do you give no margin of appreciation at all to the argument of the opposing side that the Aulic Council should be allowed to develop a coherent law of the empire without our tribunal denting it?
Madam Arbitrator, actually the Aulic Council as the Supreme Court of the Holy Roman Empire is entitled to judge and decide on the disputes which are related to the intra-empire disputes which are within the territory of the Holy Roman Empire. However, the claims here are against Philip II, and even the loans granted to the emperor are invoked. It is the claimant's submission that all these claims and loans are attributed to Philip II because it was recognized by the Spanish court and recognized by Philip II in the Settlement 1562.
Not sure that answered my question, but let's move on.
Any other questions for the claimants before we move to the respondents? Thank you. Can I then have the respondents' argument on issue 3?
Members of the tribunal, I shall now continue the case for the respondent for issue 3 regarding jurisdiction over the imperial claims. These claims relate to the loans to the emperor. Now, we argue that this tribunal does not have jurisdiction over the imperial claims because Article 26 of the CCC the dispute settlement clause is not satisfied. We have two submissions to make in this regard. First, and in response to claimant's contention, Augsburg is not a state, and thus the claimants, as citizens of Augsburg, are nationals of the Holy Roman Empire, not nationals of another state. Secondly, and in the alternative, the entire HRE should be considered as one contracting party for the purposes of the CCC. Turning to my first submission, Augsburg is not a state, and the requirement of another state in Article 2 of the ICSID Additional Facility Rules and the similar requirement in Article 26(1) of the CCC of a separate contracting party are not satisfied. Members of the tribunal, as a reminder, the present proceedings are instituted under Article 2 of the Additional Facility Rules. Article 2 only authorizes the center to administer proceedings between a state and a national of another state. Now, we say that Augsburg is not a state, that it is under the direct authority of the emperor. Now, if this tribunal can turn to page 1 of the case study, the paragraph right below the title of Free City of Augsburg and the Age of the Fugger, there it is stated that the HRE consisted of territories, some of which are ruled by princes. Now, these princes wage war against each other and even the emperor. And for the sake of argument, we could accept that such cities could potentially be independent sovereign states. However, this is to be contrasted from the present situation, which Augsburg is a free city, not under the authority of any prince. Still on page 1 of the case study, turning to the second last paragraph, there it states that some of the territories were not under the authority of any prince, but only subject to the authority of the emperor himself and the imperial diet. Now, this shows that Augsburg is not even independent to begin with, and therefore they cannot be a state. Now, they are simply a city within the HRE. And as response to the claimant submission earlier that Augsburg has signed a CCC, nowhere is this stated in the case study. And as the claimant's reference clarification number 10, that does not exist then, as I quote, all empire members ratified the CCC. It says nothing about Augsburg signing the CCC, and in particular, this is not possible since, as I have just submitted, Augsburg is not a state. Furthermore, the claimant has raised the fact that Augsburg is exempt from certain imperial taxes. And I would like to emphasize the word certain, which means that they are still subject to other imperial taxes. And furthermore, this fact does not aid the claimant, as since Augsburg is subject to the authority of the emperor, it is extremely likely that it was the emperor who decided to exempt them from certain taxes. Lastly, the claimant earlier made a submission that Spain was not part of the HRE and made reference to page 4 of the case study. However, as stated in clarification number 11, I quote, the statement at page 4, neither Spain nor Portugal was part of the empire, is for historical context only. It is not an instruction to the participants. The instruction at page 19 that all current members of the EU are presumed to be part of the HRE should be taken as is. Therefore, that does not aid the claimant in any manner, and their interpretation of the facts is simply untenable. And therefore, in light of the foregoing, we would say that Augsburg is not a state, and the requirement of another contracting party in Article 26(1) of the CCC and the requirement of another state in Article 2 of the Additional Facility Rules are not satisfied, and this tribunal does not have jurisdiction over the matter. Now, turning to my second submission to examine the dispute resolution clause more deeply, we submit that for the purposes of the CCC, the entire HRE is one contracting party, and thus the requirement of two separate contracting parties in Article 26(1) of the CCC is not satisfied. And just to be clear, this is an alternative submission to the first submission should the tribunal find that Augsburg is a state. Now, the contracting party in the CCC is defined in Article 1(2) as a state or a regional economic integration organization, hereinafter RIO. Now, we argue that for the purposes of Article 26(1), the term contracting party must refer to the entire HRE instead of individual states. And we say this for 3 reasons. According to Article 31(3)(c) of the Vienna Convention on Law of Treaties, relevant rules of international law are applicable between the parties, and this can be taken into account when interpreting the CCC. In this case, the CDP, as an international treaty binding on all empire members, is such a relevant international law. Article 344 of the CDP provides that intra-HRE disputes are subject to the exclusive jurisdiction of the Audit Council and cannot be submitted to arbitration. And this was also a query earlier raised by Madam Reid. Now, since parties must have considered their existing obligations under the CDP when negotiating the CCC, they must have intended the CCC to apply in a manner that is consistent with the CDP. Thus, parties must have intended the CDP to continue to apply in respect of intra-empire disputes, and parties must have intended to carve out these disputes from the scope of the CCC. Such an interpretation results in no incompatibility between the CDP and the CCC. Moving on to my second reason, the circumstances of the conclusion of the CCC can be taken into account according to Article 32 of the VCLT. Now, if this tribunal can turn to page 4 of the case study, specifically the first line, there it is stated, I quote, as part of his capitulatio Caesarea, Charles had agreed with the electors on certain conditions for his reign in the event of his subsequent election. And according to the next paragraph, the 4th line, these conditions include a constitution of commerce, the CCC. Now, what this means is that in exchange for the elected support, Charles agreed to liberalize trade and investment between the HRE and Charles' other existing territories, which according to the 2nd paragraph on page 4, include Spain, Portugal, the Far East, and the Americas. And thus, we say that the circumstances of the conclusion of the CCC point to the fact that the CCC was entered into to facilitate trade and investment between the HRE and non-imperial members. Now, the CCC was never intended to govern disputes that arise exclusively within the HRE. And lastly, on my 3rd point, the claimant may argue that the primary means of interpretation may be the plain wording of the clause, which require 2 separate contracting parties. Now, whilst we agree that the plain wording of the clause does state as such, this is but one method of the primary means of interpretation. The context and the circumstances that I just mentioned also fall under Article 31 of the VCLT and must be taken into account and afforded the same authenticity as the text of the agreement. So in conclusion, members of the tribunal, Augsburg is not a state. And even if it were a state, the entire HRE should be considered as the contracting party, and Article 26 is not satisfied. Now, I'll be happy to answer any further questions, but otherwise this brings me to the end of my submission.
No questions.
No question.
Thank you very much. I have no questions. We would then go to for second set of, sorry, Bartel.
Thank you, Madam President. Firstly, we did not mention that the Augsburg is not a part of the Holy Roman Empire. We did insist that the Augsburg is an independent member state of the Holy Roman Empire, just like as the European Union, which is consisted of multitude of territories which enjoys independency and autonomous. The Augsburg, however, was under the authority of the empire, just like as the member states of the European Union, which are under the authority of European Commission, but all the states enjoys autonomy and independence. Moreover, which is the claimant's submission, that the CDP is not an international convention. In the case of infrastructure versus Spain, the tribunal mentioned that that the imperial law, European law, is not an international law, it is a regional law. Therefore, imperial law, including CDP, is an imperial law and not applicable for the purposes of disputes with regard to Article 26(6) of the CCC. Thank you.
Thank you. Response?
Members of the tribunal, one point in Sir rebuttal. The claimant cannot be seriously contending that the CDP is not international law and is recognized by many of the intra-EU objection exit tribunals, such as Vattenfall and Electrabel. The CDP is an international treaty and creates international law obligations, and thus the claimant's position is simply untenable. This concludes my Sir rebuttal.
One question. Can this tribunal have concurrent jurisdiction to decide questions of imperial law?
Madam Reid, we would not agree that this tribunal should have concurrent jurisdiction. We would say that this tribunal is equally competent to interpret imperial law. However, if you meant concurrent in the sense that if there was another proceeding at the same time under the Aulic Council, then we would say, yeah, this tribunal should not exercise its jurisdiction. However, this is simply not the case on the facts.
If my other co-arbitrator has no questions.
No questions, thank you.
Thank you very much to counsel to the claimants, and also our thanks to counsel for the respondents for having submitted so ably on all the issues that have come before us for oral argument. I will hand this to the administrative secretary to give further administrative directions whilst the tribunal moves to consider a decision.
So this time we're not being moved, we are self-moving, and there's a little button at the bottom of your screen saying breakout rooms. If you click on it, and you should have a automatic sign to be moved to the breakout room.
We only have a button that says leave.
No, in the middle of the screen. At the bottom of the screen, but the middle of the window.
Ah, yes. Okay, thank you.
The arbitrators will move to the arbitrator breakout room. And if you have a button that only says leave, then please just stay.
So I hope everybody had the chance to breathe and get their blood pressure back to a normal level. So we will announce the winner and the best advocate shortly. That's obviously the privilege of Madam President. But let me just very briefly say what you can win. For the winning team, it's 3 weeks of Hague Academy. And for the best individual participant, the best advocate, it's a co-sponsored by Queen Mary, the tuition fees for an LLM in London. And with that, Madam President, you have the floor.
Thank you very much, Sabine. I would like to say well done to all the contestants. It was a really difficult decision. You were all so good, all passionate. It was clear that all of you had studied the case file, had studied the underlying legal materials, and were very well aware of the principles that needed to be argued in respect of the issues that had been selected. So well done. I am very happy and confident that international arbitration is safe for the next 50 to 80 years in your hands. We had a difficult time trying to decide. We noted that both teams in presenting their positions had more or less the same strategy, which was to start by telling us, these are the points that I'm going to make, and then going on in quick succession to make those points and explain the reason why they had taken those positions. And that is a very good way of presenting your case in case you get cut off, or as today, where you come before an arbitral panel that are unduly intrusive and interrupting and continue to ask questions. We also noted that teams showed the ability to capitalize on questions that the tribunal had asked and to respond to those questions either by answering them or explaining away the issues that had arisen as a result of their questions. There was clear discussion of each issue that the various panelists took on. And we were very, very impressed by the level of advocacy and the understanding of the legal issues. But this is something that only one team gets to win, and only one oralist gets to win. And having looked backwards and forwards and looked at all our notes, we've come to the conclusion that Singapore Management University is the winning team. So they win. Support you on that. Congratulations to Singapore Management University. And for the best oralist, tough job. But we came to the conclusion that Manoush Jambaksh is the best oralist for the finals. She did a great job. She was passionate, she was energetic, she was conversational. It was clear that she was in control of her facts. She engaged the tribunal. So well done. Congratulations, Manoush.
Thank you so much. Thank you.
And I think that brings us to the end of today's competition. I would personally like to say thank you to Frankfurt for inviting me to be part of this. And I hope that I get an invitation next year as well. Thank you so much, everyone, and have a good evening.
I want to thank everyone as well, and just say that what we've said in our tribunal, what an extraordinary privilege it is to be sharing these few hours with teams from Iran and Singapore, as Claudia Anneker said, discussing EU law. That's international arbitration.
Thank you very much. I really enjoyed these sessions, and I think you did a fantastic job.
If I may, I just want to say Thank you so much to the members of the tribunal, as well as Dr. Sabine Conrad for organizing this competition and for judging our round. And thank you so much to our learned co-counsels as well for a very engaging and competitive round. We really had a lot of fun taking part and pleading against you guys.
On behalf of MIS team, I would like to firstly congratulate the winning team. Well deserved, amazing. We had a lot of fun with your team and we learned a lot. That's our appreciation, and we truly appreciate Frankfurt for holding this competition. We had the chance to learn a lot and enjoyed the full process. And we do appreciate the presence of Madam Arbitrator and Madam Arbitrators and Madam President, and also dear Sabine. Please accept our truest appreciation. Thank you all.
Well, then thank you from me to all, to my team who helped move everybody around and during the rounds from the hearing rooms to the deliberations rooms and to the breakout rooms. That was no easy feat. And while I hope we will be in person next time, I don't know, or as trying now my hand at bad Hebrew and bad Arabic. Be'ezrat Hashem, inshallah. Be safe. Be safe, take care, and I hope the world will be better next year.